right, it is time for the legal lowdown. Many people just assume that, if you're named in a will as a beneficiary, the inheritance will automatically come to them once the person passes away. But, things aren't always that straightforward. There are a number of situations where a beneficiary might not end up with receiving the gift that was intended for them. So today we're looking at when a beneficiary may lose their inheritance and the legal rules that determine what happens in those situations. Thankfully, I'm joined in studio by Attwood Marshall Lawyers Estate Litigation Senior Associate Duncan MacDougall, because you see this quite a bit.
Yeah, happens all the time.
I don't understand, because I guess I'm like many people would just assume that because you've been named in a will, it guarantees you the inheritance because you've been named. Is that true, or can a beneficiary lose what was left to them?
Yeah, being named as a beneficiary creates an expectation that you're going to benefit.
Yeah.
But that doesn't necessarily guarantee you're going to get what the deceased has intended you to receive. Several different things can come up.
Yeah.
For example, the big one, if they predecease the deceased. So if they die before,
clearly, knocking on my coffin.
Yeah. So another factor, perhaps the will is challenged in some respect, whether they say it's an invalid will or a family, for example, a family provision comes forward, something like that. Mm-hmm. Perhaps even the deceased disposed of that asset before death, whether it was sold, whether it was gifted prior to, where a specific asset might be left to a specific individual. They said, hey, listen, I'm going to deal with this now. So there's no clawback in that instance.
I was going to say, could you contest that? Like, could you?
If you're an eligible beneficiary and you can demonstrate need, then potentially, and you.
So what then? You're going to the trust or the executor, or who do you go to do that?
You go to the executor in that instance to say, hey, listen, I'm, for example, a spouse, a child, a dependent.
I was promised a car.
I was promised this.
The car's sold.
I was there was all these intentions that I would benefit from the estate.
Right.
I can demonstrate need for further provision, and that's when that process can come out. But there's also other factors, external pressures, like maybe the estate is insolvent as well. There's no more liabilities, more debts that were due to be paid before than there are actual realized assets. There also could be factors where the beneficiary themselves are bankrupt. In which case, then that's a whole other factor as well.
Yeah, what happens there? So I've been named in a will, but I'm bankrupt at the time. Are you entitled? Because I would have thought, that solves all my problems.
Yeah.
But what happens to the gift? Is it necessarily
under bankruptcy? It's going to vest with your trustee in bankruptcy. So that's the first point of call an executor will have to make and this is very important for executors to make sure they're across or to the extent of what their beneficiaries are involved in and their own personal circumstances, because things like that where they're paid, if it's paid to them personally when it ought to be investing with the trustee in bankruptcy, certain liability can come back on the executors personally. So it's all important, even in that estate planning phase, to realize, okay, do I have some beneficiaries here that are maybe operating a high-risk business, for example? Is there some personal claim, or are there some other legal claims against them personally that's going to affect this inheritance that I intend to go to them? In which case, then people potentially look at testamentary trusts. It's a big word,
yeah,
but it's a type of will where rather than receiving that inheritance personally, you're receiving it in the form of a trust. Okay. Where there's just more asset protection, even some tax advantages that come along with those types of wills versus standard types of wills.
What about if you're a criminal? What about if you've got a rap sheet and you've been gifted something, your name is on an inheritance, your name is on a will? What happens there?
Yeah, so there's common rule called a forfeiture rule in that instance, and that's where, for example, if you have a hand in for example, the deceased death, murder, manslaughter, things like that, you don't inherit.
That makes sense.
Yeah.
That to me is pretty clear.
That's pretty clear. Pretty clear. But there's also a number of different things that'll have to come into play with the beneficiary's own conduct, whether they are perhaps incarcerated for whatever reason as well. So that's all these different factors the executors are going to have to make sure they're across before they attend to any sort of distribution.
Oh, goodness me. I cannot fathom the idea because I just wish I had like a rich old aunt who struck gold, liquid gold, and, started an oil company. I don't know.
Wouldn't that be nice?
and that I was a beneficiary, but no, that's not going to happen. Is there ever a situation where a beneficiary doesn't want to accept an inheritance?
Yeah, they can always disclaim their inheritance. So that's in an instance where, okay, I've been gifted a certain asset or a specific part of the residuary or balance of the estate, and they're saying, no, I'm not going to take it. It could very well be for their own personal reasons.
Yeah.
So maybe they are elderly, they're already receiving a pension, and they're intending that amount to go to their grandchildren or children directly anyways, to avoid any sort of Centrelink gifting rules. They may say, well, I'm going to avoid that now. Some sort of agreement can come into play.
Right.
Perhaps the parties enter into a deed of family arrangement where they say, okay, rather than this way, we're going to distribute this way.
That
it also
makes sense.
comes to the terms of the will as well. So the will might itself say, well, provided this person does not benefit, these are my residuary beneficiaries, the backup beneficiaries.
Have you ever had anyone refuse an inheritance on a will?
I don't know too many to give up their inheritance,
Yeah.
but there may be some. I've had situations where there's some it might be a strategic decision as well. So they may have already ongoing claims and things like that.
Oh, okay.
They may already there may be some family court proceedings on foot as well, where we look at the pool of assets that each spouse is going to be contributing to the pool of assets for distribution. So it comes down to their own personal factors, but most 9 times out of 10 people will be after money rather than giving it up. But again, it all comes down to more of a strategic role that they play there.
Okay, that makes more sense. I just can't imagine looking a gift horse in the mouth. The open line, thanks to Watch Smoke Alarms, is 1338 882. Or, of course, if you've got a question that you would like to ask Duncan MacDougall here in the Legal Lowdown, he's a senior associate there at Attwood Marshall Lawyers. If you would like to text through, perhaps 0499 880 882, or, of course, you can join the conversation, 1338 882. Duncan, I've got to ask, like, if a beneficiary formally disclaims their gift, does it simply pass on to the next person? So you've talked about the reasons why you might pass on an inheritance. So if that happens, that is the case, then what happens? Who gets it? Is it the next in line, or what happens there?
Yeah, again, it comes down to the terms of the will. So the will itself will have to be carefully looked at. And this is probably where executors ought to get that specialist advice straight away to say, hey, listen, these are the things to be aware of. If it's the case where there's simply no backup or no residuary beneficiaries there, the estate itself might fall under intestacy rules. So as if you didn't have a will at all, and it's down a list of eligible beneficiaries under legislation on who may receive that. Generally, down a list of spouse, children, and down that, and those are kind of your immediate beneficiaries in that case. It could be the case where it may just fall into the residue. So maybe perhaps there's a specific gift there that was given to a beneficiary. They either disclaim that inheritance or it'll then naturally just form part of the residue or balance of the estate available for whoever's left under that specific clause.
There's a fascinating case in Melbourne that I've been following with great interest about a woman who didn't have children, didn't have any family relatives, apart from a godson and a best friend, her best friend and the godson. And they were, up until 2 weeks before her death, the beneficiaries, and some sort of philanthropic purpose as well. And then 2 weeks before she passed, she gave it to her hairdresser, her inheritance. It's fascinating what's unfolding there. I can't even imagine the sort of minefield that you go with people wanting to take claim for inheritance. I guess the idea is that you should get everything done properly when you're making your will.
Absolutely. And I mean, there is that testamentary freedom, you can change your will. It's your assets. You can distribute to who you want to, but it's also important to be aware of those risks that'll happen in the event when things go pear-shaped, provided you're not providing for certain people, provided you've prepared a will when really you've lost capacity or in the process of maybe you're an early diagnosis of dementia, for example, things like that, where there could be a challenge as to the integrity of the will itself.
Sure.
So a lot of these sorts of things will come into play as too.
It's amazing. 1338 882 is the open line number. Thanks to Watch Smoke Alarms. Pat from Flagstone has called through. G'day, Pat.
Hello, how are you?
I'm wonderful. You've got a question to ask Duncan.
I do. How and is it possible if you've got estranged children that are adults? How do you stop them from actually accessing your will, or is it possible?
Yeah, so good question. So estrangement is not a complete bar from anybody making any sort of claim against your estate.
Interesting.
So it's all important, even when your own estate planning. There could be some asset protection mechanisms that you can take into place there, whether it be a change of the ownership of a property, changing certain assets to be estate assets, turning them into non-estate assets. For example, joint property, where it'll automatically pass to the surviving joint asset holder, things like that. But it's more than just important to be aware of those risks that they could very well come out of the woodworks, and say, well, I'm not getting a piece of the pie. Whether or not they're going to be successful in a claim of that nature is a different story. So it's one to say that, okay, I'm not providing for them, but it's one, and yes, they're eligible, but they may not be able to demonstrate any sort of need for further provision. Things like that. But it's all, unfortunately, there's not a hard line or hard bar against people from making a claim simply on the basis of estrangement.
Ah, interesting. I hope that answers your question, Pat.
Well, what it mainly is that, like, I'm divorced at the moment, and I haven't had any communication with my kids for over 5 years, and I've been trying to maintain a relationship with them through birthday, Christmas presents, and stuff like that, and I just get nothing back.
Yeah,
so I just really was trying to work out a way of stopping them. Look, they don't want anything to do with me, so why should they have any access to my will?
Yeah. Unfortunately, there's always this moral argument as well, and unfortunately, that's why this process exists, because there's almost an expectation that a person will provide for their immediate family members, provided that they are stepchildren. In the event that they were that divorce would have stopped that line, but provided that there are biological children, then that changes the story as well. In which case, then yes, they will continue to be an eligible person to make a claim against your estate. And by all means, I would probably recommend that you get that specialist advice to see what kind of things you can do to at least mitigate that risk moving forward.
I hope that's helped there, Pat. Thank you so much for your call. Duncan, I can't believe the time is up. It always flies so fast. It's fascinating. Please, I guess we'll be joining you. You'll be coming in next week with a legal lowdown?
I believe so. Yes.
Okay, perfect. Duncan MacDougall there from Attwood Marshall Lawyers, Estate Litigation Senior Associate. Of course, if you have a question you'd like answered ahead of time, please email us afternoons@4bc.com.au, and we'll have a chat to Duncan this time next week. Thanks so much, Duncan.
Thanks for having me again.